So today we have Tiffany Kudrovets. She is our conservatorship, guardianship, and probate director. So she is the expert on healthcare directives and why they are so important because she does help a lot of folks who need to have guardianships or conservatorships put into place because the directives are not there. So with that said, I will let Tiffany take it away.
Thank you, Carol. And thank you all for joining us on Zoom today. Again, I am Tiffany Kudrovets, and I do a lot of work with estate planning and also conservatorships and guardianships. And those sort of tie together hand in hand. So I'm hoping to give you an overview, especially of the healthcare documents, in hopes of having you or a loved one set up in terms of your healthcare needs, and then hopefully avoiding the need for guardianship. So what I'm going to do now is I'm going to try my best to share my screen so we can go through the slides. And as Carol said, if you have any questions, go ahead and ask them in the chat box, and I will try to answer them as we go through, but we'll also have time at the end for questions. Okay, let's see. Share. Let's see, PowerPoint. I think I got it. Okay. And begin. Okay. Hopefully you all can see the screen right now that has the cover page. Healthcare directives really are that important. And when I'm talking to you today, one disclaimer is that this is not specific legal advice. So in terms of what you would need in the documents, and if your documents are sufficient, we would definitely need to meet with you one-on-one. So if you have any questions that are specific to you or a family member or loved one, definitely reach out and let us know. I like to say the title of this, I should have stayed on this slide. I really like the emphasis on that important because a lot of people will come to us and they'll have a basic statutory healthcare proxy, like a paper that their doctor gave them to sign, or they'll have something that they printed off the internet. Or a lot of people say, I don't need documents. The doctor always talks to my husband or to my spouse, or I always take my daughter to appointments and we've never had any issues at all. But the documents really are important in terms of following the law. So while some things will work temporarily, in the crisis situation, you absolutely want to make sure that you're following the letter of the law, that you have documents in place, and then that you're not really just relying on, well, it worked before, or my doctor knows who I talk to. You want to make sure you have all of this actually written down, documented, and executed properly. Because in a crisis situation, relying on what maybe worked before or a basic form that's missing some provisions might not be enough. So in terms of what documents you actually need, there are a few that we recommend to all of our clients, starting when someone is 18 years old. The first one is a healthcare proxy. And a healthcare proxy is a pretty thorough document that covers all decision-making related to your physical and mental health. In the healthcare proxy, you'll name someone to act as your agent if you can't make decisions for you. And I tell people, if you have 2 or 3 people, it's a nice document where you can name a primary agent and a backup or even 2 backups. And that's because if there's a situation where a doctor or EMT or you're in the hospital and they need a quick decision, if they can't reach your primary agent or if something happened to them, you want to have those backups in place. So with respect to when the healthcare proxy takes effect, it's actually what we call a springing power. And that means it springs to life when something happens. And typically there are 2 scenarios for the healthcare proxy. One is, say that you have an advanced cognitive impairment and you can no longer make informed decisions. You can't understand the sort of your treatment plan. You can't understand the implications of different medications and if there's different effects. And so you really need someone to help you make those decisions long term. Your doctor can actually activate your healthcare proxy so that your agent is basically speaking on your behalf thereafter. A healthcare proxy can also come into play in an emergency scenario. Say that you You're in a car accident, or you're admitted to Emerson Hospital and you're having surgery, and the doctors know we need some help. They can't respond right now. They might activate your healthcare proxy just for that particular situation. And then once you're out of surgery or once you've recovered, it can be deactivated. And that's the nice thing about a healthcare proxy is that it can be activated and deactivated over time, all within the same document. The healthcare proxy includes a really tremendous amount of authority, and we include a lot of provisions that will keep you comfortable if you just have sort of routine health needs that you need, but also getting back to that crisis scenario. So for example, the healthcare document will include the ability to move you from place to place. So say you need to move from the hospital to a rehabilitation facility, or from the hospital or from your house to a hospice care facility. Your healthcare proxy will include those provisions so your agent can actually move you from place to place. Also, this is completely personal preference, but a provision that will include, if people are comfortable with it, is the ability to administer all types of medication, including antipsychotic medication. And the reason I pull out these two examples about moving place to place and antipsychotic medication is because those are two decisions that the court consider a substituted judgment, meaning someone is doing something very, very big with you, where you like moving you out of your normal place, shifting your mental health using medication. So if the court says, well, if there's not explicit authority to do that, then we want to make sure it's okay. Antipsychotic medication comes into play with a lot of my clients who have advanced dementia. It's not, and some people say, I don't want that either way, so please don't include it. And we definitely will do whatever our clients are comfortable with. But in general, the healthcare proxy has a ton of power and authority for your agent to make decisions if you can't make them yourself. The healthcare providers should be following your agent's decisions because your agent is actually speaking on your behalf. And so your agent, we'll get to this later, but your agent should actually be familiar with all of your wishes in terms of day-to-day life, medications you'll take, preferred doctors or specialists, end of life decision making. And so when your agent has that decision-making authority because your healthcare proxy is activated, your doctor should be taking direction from them. You can always, as long as you have capacity, you can revoke your healthcare proxy and you can change it. But if you're fully incapacitated, there's definitely a level of trust that you've picked an agent who's going to follow your wishes as you had explained them. The next document is a living will, and a living will in Massachusetts is not binding. A lot of people think of a living will more as an advance directive, where it's stating, if I'm in this sort of condition, like a vegetative state, an irreversible condition, a terminal illness where I'm not going to recover, I say that I would like you to let me die peacefully. And people say, well, it's like pulling the plug. But in Massachusetts, your healthcare agent is actually the one who decides that. The reason that we recommend a living will is because it takes away that emotional burden on someone to have to make that end of life decision for you. The living will is a very sort of standard template document that goes through, if a doctor says this, this, and this, and my healthcare proxy agrees, just keep me comfortable, but you can stop everything else. But I've definitely had clients tweak their documents, and I encourage them to tell me what they'd like it to say. So for example, I have a client who has asthma medication and was thinking, well, if they stop all medications, they'll stop my asthma medication, and I don't want to die because of that. You know, that's a whole different thing than dying because of my terminal illness. So we made sure in that client's living will to say, you can stop all of these things, but don't stop my asthma medication. And I've had clients who say, well, I don't want one doctor's opinion. I want them to rely on two doctors' opinions. So just know that the living will is not binding, but it gives really clear direction for your healthcare proxy and doctors to know what you would like in terms of end of life wishes. The healthcare proxy, they can override a living will, meaning that the healthcare proxy is the one who has the ultimate decision making. So your healthcare proxy might say, well, okay, doctor, I understand what you're saying, but I'd really like a second opinion. Or I know my mom told me it was really important for people to say goodbye. So even though we want to keep her comfortable, I want you to keep her on this life-sustaining treatment for another week because I have a sibling who's flying into town. But the healthcare proxy can use their judgment to make sure that that your wishes are followed, and then ultimately the living will's provisions can be what guide them. In addition to the healthcare proxy and the living will, we recommend a HIPAA authorization and release form. And HIPAA has everything to do with privacy and compliance, and doctors and dentists and lawyers, all of us have all of these HIPAA rules that we have to follow in terms of we're going to keep all of your private information private. We're not talking to anyone without explicit authority to do so. We're not sharing your records, and pretty much everything becomes personal confidential information. And once you get past the name, even date of birth, treatment plans, medication, insurance, all of those can be really hard to get access to if you don't have authority. And so HIPAA comes into play mostly, I say that it bridges the gap between you're perfectly fine and you're making your own decisions and the later stage where the healthcare proxy is activated and they already have access to information. There can be this in-between time where you think, I could really use help from someone. I don't understand the treatment plan. I'm having trouble dealing with insurance. They're not understanding what I need. I basically need someone who has all the information to be able to speak on my behalf. So HIPAA grants them access to that information so they can have conversations that involve otherwise confidential information. HIPAA also comes into play when, say, your healthcare proxy is activated and you've named your friend Carol as your healthcare agent. Well, Carol has access to all the information in terms of decision making because she's your healthcare agent. But say that you have a sibling, might say I have a sister named Rachel, and I want Rachel to be able to talk to doctors too. Or if I'm in the hospital, even though Carol's making decisions, I want Rachel to be able to call and check on me and talk to the nurses and get updates. So Rachel could actually rely on that HIPAA authorization and release forms to have these conversations. Ultimately, it would be me if the healthcare proxy is not activated, or my healthcare agent, so Carol, who would be actually making decisions. But that would still let someone else have those conversations and get updates on my care. HIPAA can be really important also because it includes access to information for a certain period after someone passes away. And I've had clients who wanted their spouse's medical records after the spouse passed away. And if you don't have that HIPAA authorization and release form, you actually have to do probate to get access to medical records. And it's a completely different webinar. We like to help you avoid probate as much as possible. So the idea of doing probate just to get access to information you could have had through a HIPAA form it's just not ideal. So HIPAA has information benefits while you're living, and then in terms of records after you pass away, if somebody wants to look at doctor's notes. This last one is not a healthcare decision type document, but a durable power of attorney is incredibly important, even with healthcare decisions. So the power of attorney covers legal and financial decision making. And so, put simply, think of anything where you would sign your name or you'd write a check or pay a bill, contracts, things like that. The healthcare proxy is making your healthcare decisions, but that doesn't mean they have access, for example, to apply for Mass Health or to sign a contract for a nursing home or to sign your name on a check to pay the bill for an ambulance or for your healthcare. So it's really important that you have both of those documents. And a lot of times for clients who are transitioning to an assisted living facility or a nursing home or some other living situation, A lot of those facilities will actually require that you have both a healthcare proxy and a power of attorney set up in advance, even if you're fully capable of making decisions at the time when you're admitted. We'll talk a little bit more, that'll come into play later also in terms of wishes and access to information. But just really quick right now, your power of attorney and your healthcare agent do not have to be the same people. So I'll talk more about that later, specific to healthcare. But just know that you can have different people making different decisions with a different priority in terms of what decisions they might be best at making. One other document that we'll mention, this is not a legal document, it's actually a medical document. It's called the Medical Orders for Life-Sustaining Treatment, or a MOLST form. And the MOLST form, I tell clients that the M is not for mandatory, but in your mind, I want you to think of MOLST as mandatory. When you sign that form, it actually has medical orders that go into effect immediately, and there's no discretion at all. And some of you might have MOLST forms from your doctors. A lot of my clients don't have them because they're recommended for people who have an advanced late stage terminal illness. Basically, when it's like when death seems imminent, doctors will say, okay, we should prepare this form. It's hot pink and it has a lot of questions on it. It's a very detailed form where you can check yes or no to different things. So for example, you can say, do I want CPR? Yes or no. Do I want to be tube fed? Yes or no. Do I want to be transported to the hospital? Yes or no. And it's a really nice form because you can actually tailor it. So you don't have to say, it's not just a DNR, I do not resuscitate. It's much more broad. And you can say, well, actually I would like CPR, but don't take me to the hospital. It's a form, and again, I said it's hot pink. If you're at home and you have a MOLST form, they tell you to put it on your refrigerator because that's where EMTs are trained to look. If you are in the hospital or facility, they'll put it on the whiteboard or the bulletin board in your room. But when a doctor or EMT or any medical provider sees that MOLST form, they have these mandated orders that they have to comply with based on what you've checked on the form. So it's very important that you know your healthcare proxy doesn't have any discretion over what you've written in the MOLST form. The MOLST form can be created with your physician while you're fully healthy and capable and you have capacity, or sometimes your healthcare agent, if you've lost capacity and it's becoming relevant, your healthcare agent can actually execute that form with your doctor on your behalf. And some people say, I don't know when that would come into play. Why would my healthcare proxy and doctor need to do that? And I'll give one example. It was a married couple, and one of the spouses was at an assisted living facility. And every time that something went wrong with his health, they would send him to the hospital, and they would fix him up basically, and they'd send him back to the facility. And the same thing would happen, and they'd send him back and forth and back and forth. And it was really taxing on the patient and also on his spouse. The medical bills were just extraordinary. It was taking a toll on both of them, and she knew for sure he would not want it to be like this. So she was able to talk to the doctor, the facility, to execute a MOLST form, so they didn't have to transport him to the hospital because their default in their contract was if something happens, we're sending the patient to the hospital. So a MOLST form can be really important later in life for your healthcare proxy to work with your doctor. And again, that's all about communication because if you don't want a MOLST form, you absolutely don't have to have one. This chart is a brief overview comparing the MOLST form with the healthcare proxy. And again, I pointed out the MOLST form is a medical document, whereas the healthcare proxy is a legal document. The healthcare proxy only takes effect if you've lost capacity. So your healthcare proxy will not be relevant at all if you're making your own decisions and they're informed decisions and you're not putting yourself in harm's way. Whereas the MOLST form goes into effect immediately. So say you sign it and then something happens, you need CPR. If you've said no CPR, your MOLST form is what controls, and there's no discretion. With the healthcare proxy, you would sign it and you'd have two witnesses sign it. In our office, we also notarize it for good measure. The most form is signed by you or your healthcare proxy, if it's activated, and your doctor. And that's pretty much it. Just remember, the M in most is not for mandatory, but just think of it that way. Healthcare proxy has discretion. So how do you choose a healthcare proxy? And this ties in a little bit to the power of attorney part. When you're choosing your healthcare proxy, it's really important to think about your community, your friends, your loved ones, your neighbors, people at your church, just basically whoever your support system is. And you want to think of someone who's going to follow your wishes, because making healthcare decisions can be very hard emotionally, and you want someone who's able to stop and say, okay, what would my loved one want? What would my friend want? And be able to make those hard decisions and be able to make them fairly quickly once they have all the information. So some clients will say, oh, I have 3 kids and I'm just going to rank them the oldest to the youngest. Or I have this child who's the closest. I'm just going to pick the closest one. And the oldest one or the closest one is not necessarily the right person to make these difficult decisions. So just make sure that you're thinking about it in terms of who's going to actually follow my wishes and be able to communicate them well. Also someone who can advocate for you, because your healthcare proxy could be going through routine decision making in terms of healthcare all the way up through end of life. So you want someone who's going to advocate for your wishes or to try different plans, or if some medication is not working out, to say, look, this isn't working out, you must have an alternative. So you want someone to actually be vocal and not just accept what the doctor's saying. You want them to think of things just as you would. And then also just someone who's comfortable doing it. There can be a lot of pressure to make the decisions. Other people might want information and want input, but you want someone who's really comfortable speaking on your behalf with doctors, communicating with your family, things like that. And I just talked about a lot of these, but you want someone who's going to listen not only to you when you're explaining your wishes, but you want someone who's going to listen to doctors and really understand, not just reactive, but actually processing the information. You want someone who's trustworthy because they're going to have access to a lot of private information and your health history. And you want someone who you can trust with that information and to make the best decisions. And then really just a decision maker. You don't want someone who's going to be like, I don't know, maybe this, I don't know, I have to ask all these people. You really want someone who can weigh all the information and actually make those decisions for you.
Hey, Tiffany,
Yes?
we have a question.
Okay.
Is a MOLST valid if you have a new primary care doctor and your MOLST was signed by the doctor who retired?
Yes, a MOLST form is technically good forever as long as you like what it says. If you don't, you could rip it up. But yeah, MOLST form, just like a healthcare proxy, is valid from when you sign it until you revoke it, essentially. Some it's a lot of times, like even when we do conservatorships and guardianships or mass health applications, a lot of those forms will actually say, does the person have a MOLST form? And so when you go to your next doctor, you should definitely give them a copy of your MOLST form, or you could do a new one with them if they prefer that. If you go to the hospital, they should know in their database and in their intake forms, you have a MOLST form. It should be something that people are aware of, and if they're not aware, that you make them aware of it. Is there another question? It popped up, but
What is the difference between a MOLST and a living will?
okay. So the MOLST is a medical form that actually says you must make this healthcare decision. Like, you must not give me CPR. You must not transfer me to the hospital. You must give me this medical treatment. So those are actually like medical orders that a doctor has to follow. A living will gives guidance for your healthcare agent to say, I want this to happen. I want to die peacefully. You have to think of them. Let me see if I can go back. we're not in person, so I can't like do all my hand signals. So if you look at this with the side with the most form, a most form is mandatory, medical treatment or non-treatment, whatever you decided. The living will falls under the healthcare proxy side of the screen. So your healthcare proxy has authority to make decisions based on your wishes in your living will. The living will has nothing to do with the most form, because if you said something in the most form, like say you say I want the ventilator, I want to be tube fed, I want to be transferred to the hospital, all of those things in the most form are going to override those specific decisions for the healthcare agent. So for example, if your most form says something specific and your living will says, well, I want to die peacefully, your most form is still going to sort of win in the balance between those two documents. So a living will is guidance for your healthcare agent. The most is a medical form that your doctor's going to follow no matter what your healthcare agent says. I hope that's helpful. You just have to think of them as completely separate paths. And if you have a most form, just know some things are set in stone how you've picked them. Whereas if you don't have a most form, your healthcare proxy can decide and weigh the pros and cons of different things. I will say I'm not a doctor, but I do caution clients that you should not have a most form too early if you don't fully understand it. Because if you are, say, 45 and you have a most form and it says, I don't want CPR, and you need CPR, well, your most form is going to control. Whereas you might have thought, well, actually, when I'm 45, I'd like someone to try and do CPR and do whatever you need to do. There's no discretion in the most form at all. So just be aware that it's really intended for late stage terminal illness, death is imminent. It just makes me nervous sometimes when my clients say, oh, I have a most form. And I say, okay, I just want to make sure you understand how firm that is. There's no discretion in the most form at all. If you have a most form, you'd still have a healthcare proxy, because the most form really involves like end of life type decisions, whereas the healthcare proxy goes through everything from routine care, I need help with basic things, all the way through end of life. So there's a lot of things that the healthcare proxy covers that aren't contemplated in that most form with the specific end of life decisions. Yeah, so the living will, your healthcare proxy would read your living will, and that would be guidance for them. Mostly, I think the healthcare proxy is just acting based on what you've told them because you've communicated your wishes. But it's something where the healthcare proxy could take the living will to the doctor and say, like, okay, doctor, I understand that let's say my spouse is not doing well. He signed this living will and it says this, and the doctor can say, okay, you know what, based on what I'm reading in this living will, it does sound like it's now time to take off the life sustaining treatment and just do comfort measures, and let's just let your spouse die peacefully. So the healthcare proxy would read the living will. The living will on its own doesn't have any authority. So a doctor couldn't just look at the living will and say, okay, I'm going to pull the plug. That's what this says. In Massachusetts, the healthcare agent has to speak that out loud. They have to be the one ultimately saying, okay, based on the living will and what the doctor has said, we're going to let them die peacefully. And again, that's where you have to think of the most completely separate from the healthcare proxy, because they're just completely different documents. And to understand that the most form could supersede the healthcare proxy. So
There's one more question.
it says,
So
if we are healthy in our 70s, should we cancel the most, and if so, how? I mean, this is absolutely a decision or something you should discuss with your doctor. I think if you understand the implications of canceling the most, and that I recognize your name, so I suspect you have a beautiful healthcare proxy with us. I think that you could cancel your most and say, I want my healthcare proxy to decide. You can rip it up. You can tell your doctor that you don't want it anymore. You don't really, you just basically sort of make it disappear, make your doctor know, I don't want this most form in effect. If it becomes relevant later, I'll sign one, but right now I'm not comfortable with these these mandatory medical orders because I'd like someone to try. Because being healthy and in your early 70s, I would never think to a client, oh, you should go get a MOLST form. But it's a personal decision because I've had clients in their 70s who are healthy who said, I understand it and it's what I want. But in answer to the question, you can just rip it up. You just need to let your doctor know that you've done it because your doctor probably has a copy in their files of your MOLST. So say, I don't want this anymore. I'm destroying it. Do not rely on it. Okay. We get back. Okay, so with the healthcare proxy, one other question that I get a lot is, well, I have like 2 kids or 3 kids and I want them all to have equal say, and can I just put all of them on there? And the answer is that yes, you can put all of them on your healthcare document, but simplicity is key. And it's not just simple because we have a clear 1, 2, 3, and we have names. We really want a doctor or hospital in an emergency scenario to know this is number 1. This is the person who's going to answer us. We don't need 3 people to agree. We don't need to call down the line. This person has ultimate authority to make the final decision. So with a healthcare proxy, I highly recommend that you pick a hierarchy and you pick, this is my first person. If this person is unavailable because they're incapacitated, so they're out of the country, they've passed away, it's fine, go to number 2. But I really like it to have a clear, this is my person, 1, 2, and maybe 3. With the healthcare proxy, I think it's nice to have 3 if you can. It's okay if you can't, because oftentimes people will have a 1 and a 2 or a 2 and a 3 who are related or who travel together. And I think, okay, well, if you have 2 people and they're always together, then we might only actually have like 2 people on your form, or there might only be 1 person, because what if they're both traveling together? That's just personal preference. But the successor healthcare proxy, basically we have at least a 1 and an alternate. The people named on the HIPAA form cannot make any decisions for you. The only time is if that person who's on your HIPAA form is on your activated healthcare proxy, they can make decisions. But specific to the HIPAA form, there's absolutely no decision-making ability at all.
Tiffany, we have another question. And I think you will answer it on this page. Any advice regarding the best way to approach this conversation with someone who wants to name you as a secondary healthcare proxy, but isn't providing you with their wishes or information?
Yeah, I think it's a really tricky conversation. And I imagine because they named you as their agent that they love and trust you, and maybe it's more about being uncomfortable with the conversations. I think what's important is to tell people, well, there's a couple of things. One is that, you're naming me, and as your healthcare proxy, I'm going to have to act on your behalf. How can I act on your behalf if I don't know what you want me to do? Or, you could say, I tell people like when they're thinking of who to name, and sometimes they'll be like, oh, I have to name this person here and this person in the other document because I want it to be fair. And I say, being a healthcare proxy or being a power of attorney or a trustee or anything else is a job. You have to take it seriously. You have to keep track of what you're doing. You sometimes have to prioritize it over your own life. And I think you could say, look, I'm willing to do this for you. I'm willing to invest my time and my emotional energy and to prioritize you if you have an emergency, but it makes it infinitely harder on me if I have no idea what you want done, if I don't know who your doctors are, if I don't know what medication you're taking. You can say too, how am I supposed to make end of life decisions for you? It's if you have no guidance at all, it adds such an emotional turmoil. It's so hard to decide that for someone when you have no idea what they would want done. So I think what we try to say, we have this book, Life Conversations with Your Important People, and it's hard, I think, because the person's out of state, so you might not be able to go for a walk with them, for example. But it's how they say sometimes like kids will talk more if they're in the car, so they're next to you. But if you can go for a walk with them or you visit, or you bring up just little bits of information at a time, I think that can be really helpful in terms of starting the conversation. You could also tell the person, and this would be for you all too, when you're thinking of what you need to share with other people, even if you don't tell me, which would be ideal to have that conversation and questions back and forth, write it down. Write down your medications, your doctors, if you have any strong preferences. You could say, I won't read them until I need to read them, but at least so I have some starting point. But it's really important because if you don't have that history and you don't know what's going on and you don't have any this framework to decide, let's get a second plan, a second blanking on the word, a second opinion. But if you don't, if you have no idea what they want done, how are you supposed to decide that? And actually, what in that case, what you're supposed to do is what you think the person would have thought best. But every person, every client of mine, every person in this office, we all have different views. So even doing what you think is best for them and what you think they might want might not actually be the right answer. You just wouldn't know. And then in the discussion, we talk about, and this comes into play, this book is not specific to healthcare. It also really helps with financial and legal decision making, burial wishes, who to notify, all of this. But it's really important to have a thorough discussion. The hardest part is really sometimes just getting them to open up in the beginning of the conversation. But I think if you stress to the person, and think about this when you're filling out for yourself. I want someone to act as me to make the decisions that I would make. I don't want to put a burden on someone else. I don't want it to take more time than it needs to take. All of those are things to think about when either having the conversation that you initiate with your agents or if you're willing to help someone. So the
Tiffany,
power of attorney, again, the power of attorney doesn't have anything to do with your healthcare business or your healthcare wishes, except that your power of attorney is the one who will be signing contracts, like admission contracts, care contracts, and your power of attorney is the one who has access to your finances to pay bills or to commit you, like to a rental agreement or a lease at a facility. So your healthcare proxy and don't your healthcare proxy gets to make healthcare decisions and your power of attorney gets to sign the paperwork and the contracts to go with them, but your power of attorney doesn't get to supersede your healthcare proxy. They're just completely different matters. Some people will have the same person will be the power of attorney and the healthcare proxy. And some people don't. And I think there's nothing wrong with either of those. Getting back to how do you choose your healthcare proxy? And we talked about someone you trust who's going to honor your wishes, who can sort of separate themselves and do what you would want. With the power of attorney, it's really important also to have someone who understands your wishes and can keep clean records. And it's someone where you want to trust them, especially if they're different people, to say, I've picked this healthcare agent and they're going to do what's best for me. I picked you as power of attorney because you're the best financially. You keep the best records. You know how to balance the checkbook and file taxes and do all of that. But each of them should know their roles. But with a lot of people will just say, oh, I just want one person, or I'm going to pick the oldest person, or they'll say, well, I'm divvying it up. But you should really think about the best person to do each of those. And they might have some personal conflicts, but I think if they understand where they fit in, it's a dynamic duo. You really need both of them, but just they're not like your healthcare proxy is not going to make your power of attorney decisions and vice versa. Okay, so we're going through quickly. We don't have too many slides left. Something that comes up often is, what if I don't have a healthcare proxy? And this can also come into play if you have an insufficient healthcare proxy. At the very, very beginning, I mentioned the statutory form that some people have, and that's really a one-page document. It's visually hard to see, but it's like this much text. It's just a blanket paragraph that says, my healthcare proxy can do anything that they need to do. So a lot of people will come to us because they don't have a document or they have something that's insufficient. And often it's because it's just the statutory form. In that case, it can lead to a possible guardianship. The problem with the guardianship is that it's a court-appointed person who's going to be following your wishes and doing what a healthcare proxy could have otherwise done. A guardianship with the court, I used to say takes 2 to 3 months, but I think I need to up it to 3 to 4 months now. And in that time, say you needed to be transferred to hospice, you can file an emergency petition, but it's still going to take 7 to 10 days. If you need to be transferred to rehab, or you're in the hospital and there's an opening for you at a nursing home, you're sort of stuck because you don't have your healthcare proxy in place. If you need antipsychotic medications, and a facility can say, well, we can't accept you because you don't have authority. Those are the types of things that could come into play. A healthcare proxy includes pretty much everything I just said. A healthcare agent can make end-of-life decisions, can determine all types of medications that you take. They can place you in a nursing home or rehab or hospice. They can move you out of state, which I think happens less here because we have really wonderful hospitals, but they can get you to the best place for care. Basically, they can do everything except for the financial part, which is why you need the power of attorney. With the guardianship, the court will only authorize what's relevant at the time. So unless someone is dying imminently, they're not going to let the healthcare proxy, or they're not going to say the guardian can make end-of-life decision making. You actually have to go back to the court and say, this protected person who I am guardian of is dying, and I need to be able to let them die peacefully. Or I want permission to execute a MOLST form. And the court will say yes or no. If antipsychotic medication is warranted and the person would have been okay with it, you have to go back to the court for that. If you want to transfer someone and admit them to a nursing home, for example, you have to go back to the court and you have to say, I need permission for this. Basically, there's so many powers that a healthcare proxy has when you have a thorough document that a guardian would need extra authority for. There's so much more about guardianship that I won't get into the details of. But just know if you can have a really thorough, beautiful document, a healthcare proxy that has all of the powers already in it, you're in a much better place. As someone who would have a healthcare proxy, when you're naming your agent, you can give them such great comfort in saying, I have this really wonderful document. It's thorough. These are my wishes. These are my doctors. You have everything you need to know. Guardianship a lot of times is a crisis situation and the person is sort of working backwards. They're saying, okay, I need to figure this out. I need to find their doctor. I need all this authority. And I'd say guardianship is the most emotional thing that I do because it's someone who desperately wants to help a person who's living but facing a crisis. So they're both going through something bad at the time. The conservatorship is similar to a power of attorney, and a conservator similarly, if you don't have a power of attorney that includes what you need, there can be a conservator appointed. It's also takes a long time. So that's why you definitely need the healthcare proxy and the power of attorney. And for many clients, ideally you will have a will and a power of attorney and a healthcare proxy at the very least. There's many other things you could have like a trust. But for many clients, if you had to prioritize, I would pick these guardianship, like healthcare documents, the power of attorney over conservatorship. I would pick those two documents, the healthcare proxy power of attorney, over anything else. Just because if you have a crisis and you're living, you're going to be stuck and someone is going to be trying very, very hard to help you. Next button. That's the end. Okay. So that's everything. But just to recap, everyone 18 or older should have a healthcare proxy and a power of attorney. With respect to the healthcare proxy, a HIPAA authorization and release allows for information sharing while you need help or for someone else once your healthcare proxy is activated. And the living will is end of life decision making. If you have questions about the most at all, you should definitely talk to your doctor and have an open conversation with it. Because we couldn't help with the most form anyways. But if you have any questions about estate planning or these documents or the role of agents, feel free to ask in the chat box now or reach out to us. Any of us here are happy to help you. That's all.
All right. Thank you so much, Tiffany.
Oh,
I'm sorry. Go ahead.
can you see the screen I just popped up, our website, or does it still show the PDF?
Yes.
Okay.
Yes.
I just wanted to show you all, this is the Generations Law Group website. I should have clicked off of it. So if you go to our homepage and you click resources, Carol put the link in here, but there's a lot of different articles that I find really helpful. We have articles and we have ebooks. But there's some in here that are really helpful in terms of the healthcare proxy versus HIPAA, things about guardianship and conservatorship and what do they mean, when does it come into play, crisis planning. So I think just in terms of follow-up on these specific topics, we have a lot of really good blog posts on our website. And then the ebooks, we have printed versions of these in our office. So if you want to pick them up, we can definitely get them to you. But I think the one that she had linked was the life conversations with your important people. But there's all kinds of other resources in here. And we have a few life conversations. The wording is slightly different, but really you can just stick with the important people one and everything will be there. But it's actually a workbook that has lines you can fill out. So, and some people prefer the workbook format, but just know that you can get that even after this webinar. Just go to our website and click on resources.
Yes. And of course, there's videos and all kinds of good stuff too. And if you are one of our clients and you're in the client care program and you have any questions regarding your estate plan, you can always call your attorney and ask them a question at no charge. So that's a nice benefit of being in the client care program. All right. So thanks everybody and have a great afternoon.